Vikas Kathuria, Manjushree, Gokul Plaha. Very well welcome to Digital Markets Research Hub. We have an opportunity to discuss with you some the latest development in regulating competition in digital markets in India, and there is a lot is going on in this really interesting and pioneering in many respects jurisdiction, and very important and powerful with great potential. And one of the most obvious development which triggers the interest, global interest to India is the latest development in regulating competition in digital markets ex ante. Namely, India aims to introduce something comparable to the DMA and DMCC. So in order to unravel the motivation, but also the juristic specificities of the bill, because in the course of the discussions on the DMA and DMCC, we learned that nuances matter probably more than first order things ultimately, as far as when the enforcement begins. So who else would be better suited experts to revert to these issues than you? And thus I propose maybe, because as an introductory cycle, maybe we can start with you highlighting to us the dynamism of and the main features maybe of digital markets in India, implying that most of our listeners are embedded in EU or UK regulatory context.
Thank you, Liz. Thank you for having me here. So very quickly, like I come to the issue why India, being an emerging market, has chosen to be on the path of enacting an ex-ante regulation. Look, India is the data richest country with 1.4 billion people, and you know, and being the third most digitalized country in the world. There's a new report by ICRIER. They come up with this report every year, and as per this report, India is the third most digitalized country. You look at the social media usage, you look at the people who are on the using e-commerce web pages, etc. So India is perhaps the biggest stakeholder in this game, in the sense that we have to agree. You read the DMA, you read the report by the Indian authority. They say that okay, digital markets are very good in the sense that they are helping people, the businesses, reach to the masses, reach to the common people. Yet there are problems. There are problems which are manifesting everywhere because of the very fundamental nature of the nature of the businesses, their business model they are choosing, and the economics of the platforms. Such kind of problems have manifested in Europe that, for the last 6-7 years, we were facing such kind of problems, and that led to many experts voicing their concerns about the ex post intervention in correcting market failures. And slowly, they paved the path to have own ex-ante regulation in the form of TFA. The trajectory has been the same in India. The global players, be it Google, Facebook, Amazon, they are facing similar kind of cases with the Competition Commission of India. And the Competition Commission of India faced the dual challenge in the sense that the tool was blunt, the ex post tool. It did not have the right kind of tools to fix the market failure. And even if it did, it was taking too long. And in the meantime, the market was tipping, and the Competition Commission of India itself says that, look, we need something. We can't just make do with what we have. Give us something, etc., extra on top of what we have. So thankfully, the government woke up to this imperative, and it constituted a committee, and the committee has finally suggested that yes, we also feel the need for having an ex-ante framework in India, and this is the proposed draft. Well, this is the small story. We are here to critique it as to why we need it, the nuances, the nuts and bolts of it.
Excellent. Many thanks indeed, Vikas. And Manjushree, maybe we can continue this explanation on the key features using, in addition to what has been said by Vikas, maybe some comparison. How do you see the evolution of digital markets? Are they more similar to what is taking place in US, in Europe, maybe in other jurisdictions?
Again, thank you all for having me here. It's a pleasure, to discuss the competition bill with experts in the field. So I'm a senior resident fellow at Vidhi Center for Legal Policy, and we worked with the CDCL committee for over a year in sort of assisting them in coming up with this draft report and the bill. So, I had front row seats to some of the negotiations that you see as compromises in the bill, and I'd love to get deeper into why they were shaped a certain way and what are alternatives, etc. On that aspect. But specifically taking from where Vikas left, two things I think are very exciting to me about the Indian digital ecosystem very specifically. One, the kind of competition that we see in the Indian ecosystem is a little different from what we see elsewhere. At least the forerunners that we're talking in, in Europe or the US, simply because in these two countries, you're talking about regulating big tech that has its roots in the US, but being regulated far more comprehensively in the EU, whereas the EU does not really have an innovative ecosystem comparable to that of India. So in India, when we look at the e-commerce market, for instance, you have Amazon and Flipkart, which is an Indian, owned company, although it's incorporated in Singapore, competing head to head with each other. If you look at the food tech market, we have Swiggy and Zomato, both of which are Indian companies. If you look at the booking, hotel booking segment, you have Make My Trip, you have Oyo, you have GoIVivo, all of which are, most of which are Indian sort of startups. So I think it's also helpful for us to reframe this conversation a little bit in terms of, sure, there is a model that may work very well for EU. I mean, whether it will work well or something is something that only time will tell us. But what is it that we need for India? So that brings me to my second question. I do agree that ex-ante regulation can help in markets that behave like natural monopolies. Digital markets is one example of them. But is it good for India for the kind of state capacity the Competition Commission of India has is a completely different question, in that the whole idea for why we want ex-ante regulation is that the cost of over-regulation is lesser than the cost of under-regulation. Now, this works perfectly if the regulation is being enforced by an authority that has the state capacity to implement this. But if we suddenly add state capacity into this equation, maybe under-regulation will win over-regulation, and we may only have to test that out a little more carefully. And I'm very excited to see how we can, bring that into the mix.
Gokul, can you continue?
Right. Sure. Thank you for inviting me to this panel. Also, I want to kind of just greet both Vikas and Manjushree. I would just like to add that I want to add the research that I carried out for the paper on whether India should implement ex-ante regulation regime for its digital markets. I came across this very interesting report that on titled "Balancing Act: The Promise and Peril of Big Tech in India" by Ms. Urvashi and Munjal. Now, while doing my research, I was hard pressed to find, you might be hard pressed to find a similar report, even in the context of developed economies. But such a report exists in India about really the impact of big tech companies in, India. The one interesting bit that the report highlights is, and this is what the approach that is adopted, that the term big tech should not be restricted to India, for example, what American tech giants alone. That the Indian startup ecosystem, dynamic as it is witnessing the rise of Indian companies are also beginning to kind of look a little bit like that, and they are beginning to they or in the future they could exhibit features similar to these American big tech companies. Now, remember, a lot of these companies have platform-wide effects. The real issue that we see with a lot of these companies, which are very important element of the regulatory principle on which the DMA is based, is that they have network-wide platform. These platform effects really come into the picture. And so when Ms. Urvashi kind of in a report, she says that in a lot of instances, the exercise of market power, the exercise of infrastructural power by a lot of these companies is having a similar effect. That infrastructural power makes, it leads to, of course, there's a tremendous amount of positive impact that both big tech companies, are having in India. But one has to recognize that infrastructural power may also lead to some negative effects. And so I would just want to kind of say that in many ways, it seems that, the Indian startup ecosystem is also kind of exhibiting those platform-wide effects that we are seeing. And in the future, even Indian companies could come to do that. Although I must point out, Ms. Aneja notes that at the moment, that's not happening.
Thank you very much, Gokul. The second round of questions which I wanted to raise, moving closer to the report itself, report of the Committee on Digital Competition Law, is somehow it resonates very well with what Manjushree articulated in her first contribution. So, Vikas, I wonder, it's a kind of hazardous tool in a sense. In order to, before introducing these rules, you as a political entity, as society, must be mindful why you do it. Why do you need it? It's not something which you are required to do to receive a loan or something, to harmonization. The motivation, the inspiration comes from the government or from the stakeholders. So maybe we can look at the driving forces necessitating or somehow channeling this societal regulatory energy towards producing the report.
Thank you so much, Oles. It's a very interesting question, and you raised a very important point. Like, let's just look at another framework, intellectual property. 2005 around, like when India was negotiating, having like a kind of a different kind of intellectual property framework for developing countries, India was at the forefront. It said that, okay, harmonization is needed. We are part of the world system. Of course, international trade is needed. There are certain bargains. There are certain trade-offs. We are also willing to make, we are willing to accept the structure. But also, please take on board, take account of the peculiarities of a developing country. We have our development need as well. So if you look at the Indian competition law, it's very brave. It's a very bold piece of legislation in the sense that it has provision against evergreening. It has provision for compulsory licenses. So a developing country could negotiate something which it really needed. Unlike that, we are in a different era altogether. Why we are in a different era altogether? Because you are absolutely right that even unlike competition law, there is no force as such, international force, which is saying that, look, you have to have this kind of structure. For the sake of harmonization, for the sake of taking loans, etc., from WTO, it's a country, it's a jurisdiction that on its own realize that something is missing in the structure that we have. Competition is good. We all agree. Whatever we say that is the end objective of competition, or whether it is contestable market, you agree with consumer welfare, you say that, okay, it's social welfare, or just say that competition in itself is the goal. But we know that it's a regime which leads us to lower prices, better choices, innovative products, etc. And also a big thing which we must take into account, it is just not the economic power we are talking about. Oles, I have seen your writings, and you have been mentioning that it is just not the economic power, it is the power to influence bigger norms such as democracy. And this is a huge power. And that is why we needed a structure. A developing country needed a structure to make sure that they play by the rules. And what are these rules? That yes, the market has to be contestable and the market has to be fair. So if you read the Indian bill, it has the same objectives, contestability and fairness. And as Manjushree mentioned, as Gokul mentioned, we have our homegrown startups. And even if they become gatekeepers, I don't see any reason why the rules must not go after them. Because eventually it's the consumer that is at the heart of competition law. It is not the, money makers are important. They are job creators, but they have to play by the rules to ensure that the market remains open for everybody. Democracy economically and democracy socially, competition law structure ensures. And that is why India has chosen to have this kind of similar structure.
Many thanks indeed, Vikas. And maybe, Manjushree, we can continue describing in more detail the setting, the institutional setting of the report, who commissioned it, how long it was working, but maybe also something about motivation and driving force.
Sure. So that's actually quite interesting because something that is very peculiar to me about the digital ecosystem in India, and generally how network markets of this nature work, is that there is not a single identifiable way in which we can circumscribe the power of big tech companies. So when you look at big tech, you're talking about its societal wide impacts on consumers, those that do not even consume its content in the economic sense. And that for an Instagram or a Meta, I'm not really paying a fee to consume it, but I am a consumer in some sense of the word. Then there are business users on the other side of it. There are gig economy workers. So suddenly, when we talk about big tech, the kind of considerations that come into question are manifold. So that is one part of it. Now, the second side of this is precisely how India, what motivated India to even commission a study of this nature. It is precisely the fact that competition in digital markets was not an end goal in itself, as much as the lack of competition led to a bunch of issues in terms of publishers having to fight for what their content versus their rights over their content in terms of fees and the like when it's published on big tech websites. There being some sort of oligopolistic concentration in the food tech market, for instance, or self-preferencing by some big tech companies such as Amazon with its own brands like Solimo, etc., that was sold and on the same platform, that was competing with it, that it was hosting other products on while still competing with those products because it had infrastructural power, as Vikas put it. So these were some of the cases that were brought up before the CCI, and they were again dealt with in a very fragmented fashion, and until a point at time in which the Finance Committee, which is last year, came out with a recommendatory report saying that we need to study these anti-competitive practices in big tech by looking at the source of where it derives this sort of a bargaining superiority from. So that was the genesis of why this committee was constituted. So the committee was constituted in Feb last year in 2023, and the report came out in March this year. So the committee deliberated for over a year on whether we need ex ante, what is it going to look like, what should a draft proposal for it resemble? Do we go with an existing model? Should we reinvent the wheel all over again? So all of these were considerations before the committee, and you see that to be a culmination of what is now a 200-page report along with a draft bill. And public consultations, again, thankfully have been extended till the 15th of May. So I think there is still some time in India that think tanks like us have to drive this conversation further on what could be the most ideal version of this bill, or what could be the most ideal version of regulating big tech. So the way I look at it is that competition and regulation are on either ends of the spectrum. Not really free market and competition and regulation. Let's look at that spectrum. There are sometimes you regulate for the sake of regulation. Sometimes you regulate to ensure that you restore competition in a market. So I think with this bill, those lines are getting very, very blurry. Are we going for regulation, or are we going for enough of a regulatory regime where we're restoring competition? I think those answers aren't very clear. That's also because competition thinking in India is not as mature as it is in the EU or in the US for that matter. So I would really be happy to see a bill that strikes the balance between understanding that we're regulating the digital ecosystem for the purpose of restoring competition, but not really because we want to regulate to rent seek, which has been a problem with the Indian government in the past. So I'm just hoping that that is not the flavor that the CDCL bill and the report finally take.
Many thanks, Manjushree. Gokul.
Right. Thanks. I would just like to start by reading the preamble to the draft bill. It reads, an act to identify systematically significant digital enterprises and their associate digital enterprises, and to regulate their practices in the provision of core digital services, keeping in view the principles of contestability, fairness, and transparency. So that's one, the EU's bill has really speaks about fairness and contestability. There's this, in the Prof bill, there is this kind of emphasis on transparency with an objective to foster innovation, promote competition, protect the interests of users of such services in India, and for matters connected herewith and incidental thereto. So it seems that they want to keep intentionally, they want, that the regulatory philosophy really is sought to be broad in that sense. I would just want to add that as far as the motivation here seems to be, the motivation here is concerned, it seems to me that and I've had the fortune of reading your paper on the DMA, that it's a sui generis regime. You call it antitrust plus, and so it seems that that broader regulatory trend all across the world seems to have sort of made the parliamentary committee believe that there needs to be a law. And the parliamentary committee goes so far as to really say that a law modeled on the DMA should be considered. So the remit that was set, by the committee was rather in line with the regulatory philosophy. And that's what we also see, as we will later discuss, and that's what also seems to have happened as far as the particulars are concerned.
Many thanks indeed, Gokul. The next question I propose for us to consider before moving into more technical details, which matter most, as we all understand, is you've been present at the discussions underpinning the DMA, the adoption of the DMA and the MCC. So you know the context and you know the tonality of the discussion in Europe and in the UK. So from your experience, subjectively, how does it feel in terms of India? Do you see the main stakeholders trying to sing very well-known songs about more evidence is needed, etc., or many other strategies? What is the role of national players? How is it likely that they will be designated, or do they consider this proposal more like as a driving force for opening their markets? Some specificities may be about the Indian context. Vikas, please.
Well, always you see a big regulation is coming up, and of course there will be forces against it. Every regulation has a cost, but every regulation and most regulation have their pluses as well. In this case, I believe that pluses are more than the minuses, right? The positives are more than the negative sides. Definitely, and hence we need it. Enough has been written, people know about it, economies of scale, scope, network effects, lock-in effects, etc., that justify the enactment of regulation in the form of DMA or the draft digital competition bill. The preamble of the DMA gives enough justification. If you read the report, the CDCL report, it gives similar kind of justification, right? So I'm not going to get into the justifications of it. I'm just briefly talking here about the opposition that we are having. Opposition is definitely coming from the industry, those who would be perhaps who would become gatekeepers. Opposition is also coming from those who are not able to understand that a level playing field is actually good for any jurisdiction, for any market. And let's just try to understand that unlike digital data protection, or unlike any other legislation that is applicable across the board, this kind of legislation would be only applicable vis-a-vis gatekeepers. And if somebody tells me that gatekeepers do not have enough money to hire people who can help the commission or help any regulatory body to see that they are playing by the rules, I do not buy this argument. Of course, there would be cost, but I think these cost is important cost to ensure that these businesses operate for the welfare of common consumers. And if you look at India, as Manjushree mentioned, as Gokul has also mentioned, and it's very evident, like, you know, all these cases that have been brought up before the Competition Commission of India, who are the people who filed these cases? These were Indian startups. And there is something very peculiar with the Indian market is that unlike EU, here e-commerce is a duopoly. In this country, ride-hailing services, they're duopoly. So we can't even use the ex-post mechanism of Article 102 TFEU because there is no dominant player as such. So we were just waiting and watching. In the facts, Manjushree just mentioned, like about stealing the data of the business that a particular platform was hosting and throwing the very host to the page number 3 after coming up with their own white brand. The Competition Commission of India could do nothing. It was a silent spectator. It came up with the suo motu cognizance, but in a month's time they dropped because they said that, oh, sorry, we do not have the tools. So that is why I think that, and I agree. One thing I would say that, okay, I'm a big supporter of, we have been a big supporter, like Ascola, under the aegis of Ascola, we organize many seminars, etc., to support this kind of legislation. But another thing is to take on board the comments and criticisms and the concerns of the industry, which unfortunately is not happening the way it should happen in India.
Many thanks, Vikas. And now, Manjushree, maybe you can continue on this.
Sure. So, yes, I think I definitely agree with Vikas here. The way the criteria for who is going to be recognized as an SSD is framed in the draft digital competition bill is agnostic to whether it is a foreign player or an Indian player. I think the report is also quite mindful of the fact that this is an Indian ecosystem that has its best days of digital revolution quite ahead of it. So, it acknowledges that, but I think again there is a twofold problem that I still foresee here. While I agree in principle that this is a great model to go by, the hypothesis comes with its own assumptions. The assumption being that we have an informationally dense setup in the CCI that is able to preempt the market in a way where it is able to stay several steps ahead of the market to make meaningful ex-ante regulation. That's not something that I'm completely sold on at the moment. There is perhaps a need for us to sequence our steps in a way where we think of capacity first and regulation afterwards. I'm not disagreeing with the fact that ex-ante regulation is needed to bring about a competitive structure in digital markets, but I'm only on the question of sequencing it, and that what comes before regulation is perhaps regulatory capacity, because the chilling effect on innovation in terms of a poorly thought out regulation may be far more, even if it is not intended for it to be the case. I mean, we're seeing several aspects of that in the DMA right now in terms of confusion, in terms of the amount of compliance that is going to be hit. And the thing that worries me the most is that the way these, the way we have sort of framed the metrics for who is going to be an SSD does not really rule anyone out by a mere look at it. So if you can have someone that is not really a big tech company, so to speak, that is caught under this net if we don't revise the thresholds, frequently enough. And the kind of chilling effect that may have on the Indian economy is something that bothers me a little bit. So while I'm in agreement that an ex-ante regulation is the need for an hour, is the need of the hour in terms of looking at a competitive structure in digital markets, my only question is, should we think of regulation first or should we think of state capacity first? Because it's only going to be a success if we have the capacity to implement it. In the absence of that, I'm not very sure, because I saw the DMA hired the EU's commission, the EC hired about 100 new policy officers, and the DG Comp was being reorganized when the DMA was about to come out. So that's the state capacity of Europe. That is a country that India will take several decades to get to. So it's perhaps a little misplaced for us to dream of EU's capacity to enforce an EU-like law. And maybe a good example for us to look at, I mean, I agree that ex-ante regulation is required, but in terms of what model may be more feasible to us, I'm leaning towards Japan, actually, where we have a very simple principle-based understanding of you're not supposed to discriminate, you cannot do X, you cannot do Y, very, very simple, very, very simple principles that certain platforms have to abide by, as opposed to going through the complex DMA model, which again presupposes that India has the capacity to enforce it meaningfully.
Many thanks, Manjushree. Gokul?
Thank you. I would really want to start by saying I fully concur with Vikas's view. I also agree with a lot of what Manjushree has said. Let me just point out something interesting. As Vikas said, there is pushback against the law from some quarters in India's public discourse. As it happens, even before this report came out, there has been pushback against this legislative initiative from various quarters. I want to point out that a lot of these arguments in India seem to be just like the problems facing, just like the law is broadly along the lines of the DNA. The arguments raised by the critics are also quite similar. In fact, I write about this in detail in my paper, which is titled "Should India Adopt Ex-ante Regulation for its Digital Economy?" It's a fairly long paper where I carry out an elaborate analysis. And so those arguments that the critics are raising are also are quite similar. Let me just talk about this theory. A lot of those arguments are based on William Baumol's theory of contestable markets, according to which market competition should be assessed not in terms of rivals' market shares, but the threat of competition. Now, this theory is supposed to be especially applicable to markets with low entry barriers, low exit barriers, low sunk costs, and easy access to technology. Now, because the digital technology often exhibits those characteristics, it may seem that everything is hunky-dory, everything is fine. But this theory cannot really adequately explain competitive dynamics in the digital economy. What are the reasons? Those reasons are today in reports published by governments all across the world, including now in India. We know fairly well why that is happening. The second argument that is often raised in this context, and this is also gaining traction in other jurisdictions, especially the United States and even in Europe, is that look at this argument. Look at the United States. Where is regulation in the United States? There is no regulation in the United States. They're still they're still hauling up companies in courts. No ex-ante regulation, no nothing. But they have such a dynamic startup ecosystem. American companies are household names. They're world leaders. They're pretty much known across the world. Where is regulation in the US? And so that means that, well, maybe regulation is the problem. Now, very recently, and this is very important, Professor Anu Bradford of the Columbia University has written an important paper saying that, the argument that Europe doesn't have its own digital giants, but the US has its own digital giants is not because the EU is regulating and the US is not regulating. The reasons are different. What are those reasons? The reasons are, first, very deep capital markets that allow financial capital to be put to entrepreneurial use, a culture of entrepreneurship that encourages risk taking, access to a diverse pool of access to talent, a talent pool that is that include a global talent pool. Interestingly, I read the other day that Chinese AI researchers want to head to the US for their research. So the argument that the US has these companies because this old dictum that the US the US innovates and Europe regulates. I think that this is the argument that she kind of discusses in great detail. And she also talks about how these are probably the points. There is another argument that is raised, which is that a lot of the times this is that the reason, the fact that ex post investigations take a long time as opposed to ex ante regulation, that this is not a bug but a feature of digital markets, which should be welcome. But now, as we know from regulatory experience all over the world, from Europe, including from India, the Indian regulator has time and again voiced its concerns about wanting to intervene in a timely fashion. An ex-chairman of the CCI has made a speech in 2022 to the same effect. And even the U.S. subcommittee on House Committee, the U.S. House subcommittee on ethics has also raised these concerns. So I would just want to point out that those arguments which are raised in India, the Indian public discourse is not witnessing some very radically different arguments from the rest of you. The law and policy rationale undergirding arguments critical of regulation are quite similar.
Okay, thank you very much. Thank you very much, Gokul. Vikas, you wanted to comment on something?
Yeah, I want to comment on what Manjushree said. Manjushree, here I disagree with you when you mentioned that just because we do not have capacity, we should look for some sort of different kind of framework. I think that when somebody with respect to developing countries says that you should be choosing a suboptimal framework because you do not have the capacity, it's a rather condescending view that developing countries cannot increase their capacity. Let me just tell you, right? India has the second largest army in the world with 1.4 million active personnel. It is the biggest democracy in the world. The Election Commission of India is conducting the biggest exercise of franchise power in the world. When India can manage this thing, it can definitely manage to strengthen the regulators. And it would be all the more easier to strengthen the CCI because CCI does not have dearth of money because the money from the fines and penalties goes to the coffers of the CCI, does not go to the consolidated fund of India. Please, let's just understand that, yes, I agree that at this point, we do not have the capacity. The Competition Commission of India, with its limited personnel, is overstretched. But the committee itself says that, yeah, you should have a digital market wing. So yes, definitely there is a reason. I have accepted it in my blog piece that they should definitely be increasing their capacity, but just because they do not have the capacity as of now, they must not choose something which is suboptimal, because suboptimal rules would ensure suboptimal outcomes, which is not good for everybody.
Many thanks, Vikas. Manjushree?
So just on that point, Vikas, I completely agree with you that the model that we're currently hoping for is aspirational. I agree that it is perhaps not an idea that we want to dwindle down on our aspiration for what an ideal digital competition, what an ideal digital market in India would look like. But 2 points on state capacity here. One, first, at Section 51 of the Competition Act very clearly says that all penalties and fines, in fact, go to the Consolidated Fund of India. Only the fees from filing combination applications stay with the CCI. And yes, that's been increased in the past couple of years, but that's not seen a proportionate increase in the number of staff that the CCI has had. For instance, the CLRT report recommended a much wider, whole-time member panel along with some part-time members that could have some sort of an intermixing on who's going to do policy advisory and who's going to do adjudication, because the CCI right now is trained with 3 whole-time members that are doing policy, advocacy, whole-time hearings, etc. Of course, they have an army of staff below them, but most things are signed off by 3 members of the CCI, including the chairperson at this point in time. So in terms of the kind of capacity that we'd like for an ex-ante regulation to have, both in terms of experts, both in terms of who understands digital markets better, how are these regulations going to be framed? Because I'm this worried simply because so much of the substance of the digital competition bill is in fact left to regulation. So we don't know how these obligations are going to look on SSTs until the CCI comes out with regulations that can meaningfully fix this gap. So for this to happen swiftly in a way where we want the source of ex-ante regulation, that we want to sort of catch flaws in the market before the market tips, I'm not sure is going to be meaningfully achieved unless we staff the CCI with the requisite experts that are capable of coming up with these kind of regulations. And on the question of, whether I may have to disagree with you here in that we may have a huge digital market, we may have a huge army, but I'm not sure if that translates into regulatory state capacity. Yes, these are indicators of how well India is doing, but whether that translates meaningfully into how the government state capacity is reflected, because there's tons of literature that talks about how India has a large bureaucracy, but the bureaucracy is not very efficient for a lot of reasons that are outside the scope of one regulatory body itself. So these are large institutional problems. And all I'm trying to say is that here, in a situation where we are looking at the digital markets, the digital markets bill, in this case, the Indian bill, as some sort of an instrument that plugs the overall gap that exists in India in terms of tech regulation at large. I think capacity building comes before empowering an institution. I think if I were to sort of draw this out in terms of step 1, step 2, step 3, step 4, I think first strengthening CCI, because there is already a mechanism available under Section 33 of the Competition Act where interim measures and interim orders is something that the CCI can still, do if it thinks that the market is in a state where it will tip before it finishes its investigation. The Facebook WhatsApp merger, in fact, was referred to for an interim order, but the CCI was unable to do something in that regard. And in terms of how, Section 19(4), which is the equivalent of what Section 19(4) and Section 4 in the Indian Competition Act are equivalent to 1 or 2 in the TFU in terms of how we understand dominance. It was pretty wide enough for the CCI to at least issue guidance notes or, some sort of studies on how dominance could be interpreted in this market. So I'm not sure if the answer to capacity issue is more power. I think capacity and power are 2 distinct parts of the same equation on what makes effective regulation. And I would much rather see capacity building first before we empower an institution to do more.
Okay, so let us agree that we have variety of views in terms of the need for such tool. But let us move to the second chapter of our conversation, looking at the bill itself, namely the technical features And the first is designation criteria, because we understand it's like with EU and UK, it's you are designated and the whole cascade of rules or obligations are placed on your shoulder in a large backpack. If you are not designated, or most, if you are not designated, you are expected to be a beneficiary of the system, because your main competitors will be slowed down, let's say, in terms of in the burden of compliance, etc. Thus, drawing the line correctly is of quintessential importance. Maybe you can reflect, let us start with you, Vikas, again, on designation criteria as proposed in the bill, and who is likely to be designated. Is it likely, again, be one company per core platform service, or core digital service as it's called in the bill, or more than one per service?
Yeah, always. This is a complicated because I'm still trying to compare these two structures, the Digital Competition Bill and the DMA. My preliminary reading is that, it's not very different. The way affiliated digital enterprises have been defined, and the definition of group enterprises, group undertakings in the EU, it brings the structure. It makes the structure quite similar, in the sense that it indicates that we are dealing not with firms, we are dealing with ecosystems. Now, if you look at the ecosystems, they are at the very heart of any ex ante legislation. Why? Because this is self-sustaining a structure where different firms within the same group are involved, where transfer of data becomes easy. That's why there are vertical relationships where self-referencing becomes quite natural and obvious. And that is why the net has been cast very wide in both the structures. So it's just not one, one entity, but there can be several entities which can be responsible for an impugned act, and hence they would fall within the purview. So this is my reading of the legislation. And so far as the differences are concerned, I don't think that these two legislation, both DMA and the Digital Competition Bill, are taking a very different or stark opposite stance towards identifying the gatekeepers as such.
Many thanks. And now, Manjushree.
So there's one critical difference that I note in how the DMA operates vis-a-vis designating designating gatekeepers versus how the draft Digital Competition Bill understands SSDs. One issue here is that I think it's Article 3.8 of the DMA. I'm sorry if my memory doesn't serve me right, where if there are entities that meet the criteria in Article 3, they have the ability or a right given to them to come and explain to the Commission as to why they should not be designated as gatekeepers. And that there is there's an affirmative right of defense that's built into the DMA, but that's not the case with the Digital Competition Bill. In that the moment you hit the thresholds, there are no other outlining considerations that go on before you are designated as an SSD. So this deeming fiction operates a lot more vigorously in India than it does in the EU. So where this for me, this is an issue because the kind of thresholds that we're looking at under the draft DCB at this point in time, I'm not sure if there is a clear, bright line understanding as to who exactly do we intend to cover, who is going to get covered, and are we unintendedly going to cause a chilling effect on those that have not really attained that critical position in the market. So this is a critical difference that I think in that where numbers may not serve as a useful proxy under the DMA. The EC is given the right to exercise a rule of reason to say that, hey, I understand that you fulfill these numbers, but in the ecosystem within which you operate, you may not have reached the critical point at which you need to be designated as a gatekeeper. So we'll keep you out for now. Now, the India's competition bill does not build in that flexibility. For me, that's one huge difference between how the DMA and the Digital Competition Bill, the DCB, differ from one another. The second place where I think the DCB and the DMA sort of both converge and sort of diverge is the list of core digital services versus the list of core platform services. On a cursory look, they appear to be similar, but the schedule has definitions of who these what these core digital services are going to look like. And the definitions, mind you, are quite broad in India. And this is keeping in mind the fact that we have our own, rules that govern things like, OTT messaging and how video sharing, etc. works. So virtually you have a situation where the kind of players that may have been left out in EU, for instance, I think one of the major debates in EU is whether WhatsApp is a number independent interoperable service. But that's not something that is going to be a problem in India because we've just defined it as any messaging sort of service. So the kind of net that we're casting in India might be a little wider than what it is in the EU, especially when you look at the list of core digital services. The other interesting thing is also how end users and business users are going to be identified. Now, the thresholds mean nothing if we don't have a concrete definition of who the end users and business users are. The DMA has a schedule that lets you understand who end users and business users are specific to each core digital service, because each of them have their own business model. The DCB is not as nuanced. It leaves that out to the Competition Commission of India to come out through regulations at a later point in time in terms of how end users and business users are going to be identified. Both my worry and point of difference is the same, in that unless we see the substance of how we identify end users and business users for each of these core digital services, I don't think we will have a fair understanding of who is going to fall within the net and who is going to fall outside the net. But that level of prima facie clarity, I think, was already there at the statute level with the DMA, which we do not have with the draft DC. So these, I think, are some of the primary differences that come out to me when I look at both the DMA and the draft digital competition.
Many thanks indeed, Manjushree. Gokul?
Right. The only thing that I want to point out here is that the section 4.4 of the draft bill, it kind of, so it reads, upon consideration of the information received, if any, under subsection 3 or any other information in its possession, if the Commission is of the view that the enterprise meets the thresholds set out under subsection 2 of section 3, the Commission may, after providing an opportunity of being heard to the enterprise, A, pass an order designating the enterprise as SSDE, and B, direct the enterprise to show cause as to why a penalty may not be imposed. So that opportunity of being heard seems to be included in the provisions.
So that's
and also,
I'm sorry, Gokul,
yeah.
I can come in after you. Please go ahead.
No, I just wanted to kind of put that out. I've heard what Manjushree has said, and section 34, I think the appeals process kind of allows you to also take the matter to the CLRT if need be. Just wanted to put that out.
Manjushree,
So,
you wanted to reflect in one sentence or two sentences?
Sorry, just give me. Sorry, do I reflect on this right now, or should we do this after?
Let's no. I thought that you wanted to say that that this opportunity is, well, yeah, maybe we can when we discuss efficiency defense. So I understood we can skip the question on regulatory dialogue, because it looks that the Commission will have a lot of discretion, and thus soft power, or however we can label it, will be within its capacity. So the next question, and here we see huge difference between EU and UK obligations, not only the substance of obligation, but also the opportunity to tailor individual bespoke obligation for each specific designated undertaking. Where would you position the bill, Vikas? Is it closer to the DMA, to the DMCC, or something sui generis?
Yeah, always. No, this is something very interesting, and this is I would say the Achilles heel of our draft, in the sense that, let me try to explain that. By the very nature, there are certain practices which are hazy. They fall in the gray zone, using the language from the EU, in the sense that neither the regulator nor the enterprise knows what is going to be the outcome of, whether it is good or bad. Like, say, for example, interoperability with the operating system, or maybe it is good, maybe it is bad, I don't know. In this case, what I seek is a dialogue with the regulator, that come talk to me, this is the requirement. However, in a sandbox kind of environment, let me show whether it is working or not. And if you say that it is bad, I will say that it's my compulsion not to allow this kind of interoperability, and I can show you. Now, there can be two ways to go about it, that every time for such kind of practices, I sit with the enterprises, I try to understand their business model, I try to understand their technology, and then I take a considered view. Okay, what are the problems with this kind of approach? This approach is more scientific, more nuanced. The problem with this approach is it is a bit time taking, and the second, that it requires a lot of capacity, because every time I have to sit with an enterprise. The other side is that I do not allow for this kind of participative regulation, and I say that for every practice which has been prohibited, the commission comes up with kind of a regulation. Now, I say that it is not scientific in the sense that the business models are changing rapidly. The technology is changing very rapidly. And the kind of technology, the practices that you employ, I being in the same relevant market, borrowing the terminology from the ex post competition law, may be using a different technology and business model altogether to reach out to my consumers and business users. So I believe the first structure of participative regulation is far better compared to leaving every nuanced detail to the realm of regulation. The Indian structure, unfortunately, has chosen the latter, which I believe is not a right thing. Leaving too much to regulation, we need to understand one thing, and here, age-old wisdom that we have gained collectively as you know, being in the market regulation, is that regulation has a cost. Regulators do not have the same kind of information as regulatory firms. And also we need to understand that not every regulatory decides to be on the wrong side of the law knowingly. Maybe they don't know and they are doing it. So I just sit down and try to participate with each other. And this is my recommendation on the Indian structure.
Thank you very much, Vikas. Manjushree.
So I'm just gonna, sorry, again, I'm just gonna go back to the one question on what's, sets DMA and the DCB apart. I'm sorry, I think I got the section of the DMA wrong. So this is 3.5 of the DMA that says that even if a gatekeeper or a potential gatekeeper meets the quantitative criteria under section 3, that is the turnover, etc., they can still come to the commission and say that, hey, listen, I've met these criteria, but I'm not a gatekeeper for XYZ reasons. In India, however, that power is not there if you meet the criteria. So there are two sections in section 3. There is section 3.2 and there is section 3.3. 3.2 gives the commission the power to designate. There is no power, in fact, it's a deemed designation for anyone that automatically fulfills the criteria. But then the CCI can also exercise discretionary power to designate someone as a gatekeeper. So the ability to present your arguments and go for an appeal is only when CCI exercises its discretionary power. But the understanding is that if you meet the thresholds, the numeric thresholds given in the draft TCB, then it is set in stone that you are going to be designated as an SST. That's the difficulty that that I have with section 3 and the section 3 of the DMA and section 3 of the Indian Digital Competition Bill. Now, this very neatly ties into the question of obligations as well, in that I think the understanding of what sort of obligations we want to impose on entities is entirely depend on who we want to regulate. And the sections that tell you that who you're supposed to regulate is sections 3 and section 4. In that, because let's be mindful of this, in that this is an experiment. Ex-ante regulation is still at an experimental stage globally. We still have to wait to see how different economies respond to this, how whether this is the sort of efficiency that we are aiming to have, because one of the strongest, the steelman of arguments as to why you shouldn't have an ex-ante regulation is that, hey, this is very good for consumers in a completely different sense of the world, because sure, I'm maybe trading in some privacy, but in terms of the kind of advantages, the kind of convenience that it grants to certain consumers, it is impossible to deny that big tech has and general digital ecosystem has brought about a bunch of benefits. I know this is the steelman case of that argument. There are several problems with this understanding, but that is one thing to consider as well. Now, in terms of the obligations on this, in that I think because our obligations have to respond to the ecosystem in which these SSDs operate, I think it's very important for us to come up with a precise understanding of who is it that we want to go after and what do we really want to go after? What sort of practices do we want to go after? Because we do understand that these companies have some sort of benefits in the market that we do not want to trample down on. So On the obligation side, I completely agree with Vikas, and I think this is something that the Parliamentary Standing Committee also identified, in that there are certain practices that we understand that are, problematic 9 out of 10 times. And let's ensure that they are encoded in the draft bill as such. But there may be some practices such as tying and bundling, which may in fact be beneficial to certain market segments for reasons that we may not be fully able to foresee and comprehend at this stage of drafting. So we will let a more, an efficiency-based approach play out there. I think this has been the founding philosophy of how the obligations were thought through, at least in the committee meetings. But again, this leaves a lot for what the CCI is going to come up with, because under Section 7 of the Draft Digital Competition Bill, the obligations will only be enforced when the CCI comes up with regulations on them. And the regulations are also going to be core digital service specific. So how are these obligations going to hit e-commerce giants is going to look very differently from how these obligations will hit a search engine, for instance, or how it's going to hit an app store, for instance. And I think we'd all be kidding ourselves to think that this is not going to have some sort of a reality, play into it, and that India has seen the most number of complaints, I think, in the app store economy first, and not really in the video sharing sort of segment. So I think the way the CCI is going to respond to this will also reflect reality. And if that's the case, I think we should also think a little hard about who is it that we really want to go after, because we do not want to really be going after someone that is ranking 4th, 5th, and 6th in the list, because then you are sort of strengthening the power of big tech again, because they are the people that have the wherewithal to, take on an extra burden of regulation. But maybe someone that's a startup that's doing really well, but somehow comes to, hit these numbers and gets clubbed in with the other SSDs, we might be doing our economy a disservice then. So I think for me, precise identification is a pre-step that would make obligations successful.
Thank you very much, Manjushree. Gokul?
Well, I will make a few very quick points. First, what I would want to say is, and I think this is where I kind of, I understand where Manjushree is coming from when he says the question about regulatory capacity. Why am I saying that? Section 21 of the draft bill reads the title, Power of the Commission to regulate its own procedure and conduct studies. And so it seems that the committee wants the CCI to do the heavy lifting when it comes to identifying who should be regulated, what are the circumstances that warrant why they should be regulated or not regulated, whatever. So that's one thing I would want to point out. The second thing I want to point out is that when it comes to who's going to be designated, just like the DMA, the scope for saying I shouldn't be regulated is less in the Indian law. So I would kind of think that there is not that much of a difference. The commission is going to hear you out, that's for sure, but that's about it. That's quite unlike, for example, the DMCC bill, which also you have written so much about, which has this this provision about countervailing benefits exemption, right? Now, interestingly, just about a few days ago, I read this. I read this paper, or I began reading this paper by Professor Massimo Motta. Pardon me, if I'm pronouncing his name correctly, in which he describes the theories of harm in the context of self-preferencing. But importantly, he acknowledges that in some cases it could be objectively justified. And so the DMCC bill seems to have that flexibility of allowing countervailing benefits exemption. That is in many ways missing from the DMCC bill, and also perhaps from the bill as it is currently structured. Maybe the central government has the power to make rules. Let's not forget, under this law, the commission has the power to frame guidelines, to issue regulations. So there's a lot that could happen in that context.
Thank you very much. Thank you very much, Gokul. And you open the door to the next question, which I wanted actually to ask you. We have two very different approaches to the efficiency defense in EU and UK legislation. How this mechanism is being proposed in the new bill, Vikas?
Like they have raised an issue on which there are many different voices, like efficiency defense. If you look at it, efficiency defense within the framework of 101 or 102, it is important, right? Although, like more often than not, due lip service is paid to efficiency, even in the commission decisions, etc. You see that okay, we looked into it; they are not proportional. We have the 101 3 framework, the 4-prong test, and any efficiency, argued efficient, has to fit within this framework. Well, it has been very difficult, very difficult. Just before the advent of digital competition law, there was a wave in Europe by this name of more economic approach. The more economic approach was taking the stance that we are more scientific, we are arguing for, taking into account the efficiency difference, etc., etc. But somehow this movement could not like bring out enough results, in the sense that the competition law regime was faced with new challenge in digital economy, and people started focusing on this part. Now, let's look into the efficiency defense within the framework of ex-ante regulation. It has not been mentioned even once, so far as the digital competition bill in India is concerned, or the DMA is concerned, that efficiency defense is granted to the undertaking or to the enterprise. What could be the reason? The reason could be that contestability and fairness in and of itself is considered such a huge goal that no kind of efficiency can offset the harm, and hence we are not choosing it. We are not even going after it. The only difference that you can bring up is a business justification. We are doing it because it is important. Otherwise, it would not be possible for us to survive. So business justification has been granted, definitely, but efficiency defense in this realm has not been accepted as such. Well, should it be provided for in the Indian digital competition bill as such? I would say perhaps not. We don't need it as such, because it would be very difficult to balance out. Like what we are faced with is the structure of digital markets. The digital markets, the harms are enormous. Look at the technology that we are talking about. Collectively, the economic aspect, the technology and the underlying economics tip the market in favor of the incumbent firm. So even if we are talking about efficiency firm, the market concentration would be so high that in and of itself, it would be a bad thing. We are here talking about contestability. Stricto sensu that market should be contestable. We are not happy with just one player. However, the economics of digital market is such that invariably it would tip in the favor of one platform, and no amount of efficiency can offset the harm. Here, once again, I take you back to the point that I was making some time back. The harm is just not to the economy, the harm is also to the democracy and society. So that is why perhaps the Digital Market Act or its Indian sister digital competition bill say no to efficiency.
Many thanks, Vikas. Manjushree.
I completely agree with Vikas on this. In fact, that was the underlying discussion in the committees also as to why we left out an efficiency-based defense. That is because it's easy to argue for, it's easy to demonstrate efficiency when you have a first mover's advantage coupled with network benefits, network effects that sort of strengthen your position in a way where you are invariably going to be the best guy on the market to offer that said service. But that being said, efficiency is a proxy for the overall health of the market. And I think the draft digital competition bill thinks that a more effective proxy for that is contestability as opposed to simply efficiency. Or at least that's the underlying discussions, the undercurrents of some of the discussions within the committee itself, in that we're seeing contestability and efficiency as different proxies for understanding the overall health of the digital ecosystem. And in a situation where there's a trade-off between contestability and efficiency, maybe we should veer towards contestability. That has been the philosophy, yes. But what does this mean to efficiency then, when cases are brought before the CCI or when regulations are going to be framed, and that how much of a weightage is efficiency going to have in these regulations? Again, I don't think the report or the draft digital competition will give us enough guidance to understand how will efficiency be a factor in determining the obligations themselves. And I think that's something I'd love to see a little more debate on, because at the end of the day, that is something that's going to be hotly contested. Even when there's a case brought up before the CCI, the worst possible outcome in this is that we, move towards an ex-ante regime, but ironing out these ideas take so much time that it ends up becoming an ex post sort of a regime in how time consuming something like this becomes. So I would love to see some more clarity on this. I don't think we have it at this moment, but I completely agree with this on Vikas, and that I think the draft digital competition bill prioritizes contestability over efficiency, and pointedly so, very real.
Many thanks, Manjushree. Gokul.
Right. My view is a little different. I kind of lean in favor of the philosophy of the UK's regime, the DMCC bill, and purely from a legislative design point of view. Just being cautious. Let me give you a small example, just a small example. Recently, Professor Massimo Motta, who's a renowned competition law professor, in a new essay, he describes the theories of harm in the context of self-preferencing. But he does not forget to mention that in some cases, there may be very few. In some cases, there could be, a justification, and that is where I think the UK regime's provision for countervailing benefits exemption, I think, becomes important. Remember, here in the DMCC, India's bill as it currently stands, it's simply saying, well, no self-preferencing, that's all. But scholarship may tell us that in some cases, I'm not trying to say that, is this going to slow down enforcement is the question. Well, it probably, it's not going to harm if you listen to somebody who may have a you may at the end of the day say, no, this is not applicable. But here, affording an opportunity to parties to do that, I think, is something that the UK regime does well. I just want to also quickly mention that there are some other, the DMCC bill of the UK has some other, provisions. For example, pro-competitive interventions that can be devised by the regulator. Implementation trials. Let's try and implement a certain kind of enforcement. Let's try something out. Now, it may or may not work. Let's try it out on a trial basis. So I think that's where the overall that regime is quite flexible, and some of that flexibility, I think, is going to be a good thing.
Thank you very much, Gokul. We are approaching to the final phase of our very vivid conversation. So maybe we can also reflect on the institutional, or rather, the communication between the Competition Commission of India with the broader digital agenda epitomized by the government. So it's discretionary tool, it's kind of experimental modality, the room for interpreting obligation, or for being proactive, or rather distant from implying instances or investigating instances of non-compliance, is quite wide. Thus, so my question is, do you expect the new regime to be kind of almost quasi-automatic, axiomatic, or rather it will be an instrument for shaping Indian digital agenda, or something in between? Vikas, please.
Yeah, sure. Always, thank you so much. I think, may I, with your due permission, state a point before we get onto this question that you have asked? Yeah. So here, what concerns me is that, Europe has a huge list in Article 5, 6, 7. Okay, we are just not even talking about Article 7, but we are talking about 5 and 6. But if you look at India, India has prohibited certain practices. These are not the practices, same practices as the DMA prohibits. It's a very small set. Now, and somehow I think it is being carried forward into the new bill because the old committee had mentioned this thing. Where did the old committee get to know about these things? Because there was some market investigation by CCI. CCI said, okay, these practices exist. From there, they picked up, and finally they passed it on to the bill, and somehow the bill still retains it. Now, my question is, what is the justification? What is the justification for not having price parity clauses, going after price parity clauses? What is the justification for not allowing for interoperability? Now, if you look at Article 5 and 6, not all practices are the ones that EU or European Commission tested under the ex post mechanism. In the ex-post mechanism, self-preferencing, etc., the European Commission realized that, look, we do not have the tool, and more often than not, rather always these practices are bad, and hence we need to proscribe them ex ante. But there are certain other practices for which there was no prior institutional enforcement experience, but the economics was such that dictated that these practices should also be proscribed ex ante. So heavy reliance was placed upon economics, and rightly so, because the economics of digital markets are very much clear by now. Now, Indian competition, the draft digital competition bill and the committee should have taken a cue from these things and should have relied upon the economics, the very justification for having an ex ante bill to devise obligations and prohibitions.
Vikas, do you want to reflect on the relationship, more specifically on the using CCI as an instrument for pursuing broader societal agenda, or you would expect the regime being rather autonomous and almost self-executing, even taking into account the capacity constraints and the experimental nature of this? And which option is envisaged or is more closer in the bill?
Now, this is a question, like, I think, and if anybody answers this question, they would be speaking from their own experience and ideology, in the sense because there is no evidence to support the answer. But if you ask me, I think it's rather an autonomous institution, the institution and the enterprise of competition. And the Competition Commission of India, without any external or political influence as such, has gone after Indian firms, Indian enterprises, not just Indian enterprises, but the government and government enterprises as well. And I believe that through this new enterprise, which is ex ante in nature, the Competition Commission of India would be pursuing an autonomous agenda that is to ensure contestability and fairness. This definitely translates into level playing field, which would be good for the economy and the society in general.
Many thanks. And now, Manjushree.
So this is a very interesting question, Wallace, because I do believe that a country's economic agenda is not very divorced from its political agenda, and I think they interplay into each other in every sort of a move that the government makes, especially with regulatory pieces as novel or as heavy as the draft digital competition bill. Now, so let's break this down into two questions, right? So let's just go back to what the CCI's experience has been when it has had to compete with other regulators. So the question can also be framed as, do we see competition as a stream of regulation being enforced only by the CCI or by other bodies? I think that is part answer to this question. And I think the answer to this is actually yes, in that, sectoral regulators in India came much before the CCI. So if you look at various provisions of the Telecom Bill or the TRI Act, etc., things like pricing caps, etc., which are traditionally could also have competition implications, are very well, encapsulated in these sectoral regulations. In fact, a very good example of this is a predatory pricing case by Jio that came up right before the Supreme Court, in terms of whether, if there is a competition concern in a regulated sector, does the sectoral regulator have the first say, or is it the CCI? And the Supreme Court has answered that, saying that the sectoral regulator is going to have a huge say in terms of what the outcome of that is. And I'm not sure if that is going to change very drastically. I can imagine it going to change, because I think since then the competition regulator has also matured a lot more. The CCI has only been functioning since 2012, so it has a sum total of 12 years of experience, given there were a bunch of litigation battles that stopped it from ever coming into force the way we intended to in 2002. So it is a very nascent regulator. It is a very young regulator, and when there is historically been a regulatory tussle between the CCI and another evolved and a mature body like the telecom regulator in India, we've seen that the telecom regulator has won. So tomorrow, if there is a clash between the IT ministry or the IT regulator and the CCI, it's as good as anyone's guess as to who will win. But past experience has told me that it is the sectoral regulator that gets the first bite of the apple. So that's one. Second, I think the bill tries, I mean, the report actually in some ways tries to answer this question, in that the committee was very mindful of the fact that we cannot frame these regulations in vacuum, because, ideally we want competition, we want the draft TCB to complement every other regulatory piece of instrument that sort of addresses concerns in digital markets. So we do not want regulations to be framed in vacuum. In fact, it has a very exhaustive discussion on what are the current regulations that sort of address some of these issues, in bits and parts. So, for instance, the FDI regulations in India have an indirect ban on self-preferencing, but that unfortunately only works on, foreign-owned entities. So, competition, in fact, interacts with many other regulators and legislative instruments in a very indirect fashion, and I don't think that's going to stop. And I think that there is all the more reason for that to be strengthened. And there are many sections in the CCI that allow CCI to seek another regulator's opinion and vice versa. I hope this mechanism is only strengthened, because for something like digital markets, I've been a huge fan of a whole of government's approach, in that we don't want to get into a situation where there's regulatory confusion between two regulators in terms of what is the right thing to do. So I do hope that regulators speak to one another, while enforcing the draft digital competition bill too, and especially when framing regulations under the draft digital competition bill. So to sort of sum it up, I think this is definitely part of the government's larger, this is part of the government's call on what it understands a healthy digital market in India to look like. And competition is just one instrument for them to achieve it. There are, of course, other instruments. Only time will tell as to which one is going to be the sword and which one's going to be the shield.
Many thanks indeed. And now, Gokul.
Right. Before I respond to this, I just want to mention that perhaps, if the draft bill were accompanied with, let's say, a regulatory impact assessment that we've seen, let's say, in the EU and in the UK, that would have elaborated, we would have learned more of the thinking that went behind designing the law the way it was. So a lot of the concerns that Vikas and Manjushree have talked about we would probably have benefited much more. So that's one. Let me to answer this question, let me just talk about, let me say that and I would just pick up from where Manjushree left off about this whole thing, that the report mentions various initiatives all across the board that touch upon the digital economy, but ultimately the committee concludes that is not sufficient. That there is a need for a new regime. Let me also point out here that India's to understand India's digital regulation strategy, that we've seen how the committee has beautifully listed out most of the almost maybe all kind of legislations that touch upon or regulatory regimes that touch upon the digital economy. What we need to pay attention to is India's DPI, the digital public infrastructure, which the IMF has described as world class, by the way, and through which India seeks to kind of unbundle e-commerce, promote interoperability, democratize e-commerce, democratize a lot of these the digital space. And specifically, what's worth talking about in the competition law context? Look at the ONDC. The open network, this open network, I forget the digital commerce. Right? So this initiative wants to unbundle e-commerce. It wants to promote interoperability. It wants to allow different enterprises to compete, to challenge a lot of the market concentration that we are seeing in, for instance, India's food delivery services market. Zomato and Swiggy immediately had to slash prices once the ONDC was launched. And so it's very important to understand that is a central piece of India's really approach to the digital economy. But and my paper discusses this in some detail. Is the ONDC, for example, just for our context, is the ONDC a substitute for ex-ante regulation? And my paper concludes that it is not. Why? Because, and this is something you have, people in the government have said this publicly, that we are not see, it's not going to alter business models. The ONDC, which I wish I could speak about it in more detail, but I want to be very quick. It is not going to alter business models. And that means that at best, it can help one business model rival another business model better. For example, subscription-based models vis-a-vis commission-based models. There's this example of Namayatri in India, which wants to kind of a platform cooperative for in the online cab services market. Take on Uber, the Ubers and the Olas of India's digital economy. But since it can only help one business model rival another business model better, it is not a substitute. And that is something that policymakers also seem to concur, which is why we are seeing the laws of this. That's what I would say.
Many thanks indeed. And now we are approaching the end of our conversation. So two questions remaining. The first or the second one will be a recommendation to those who start their professional life in this time. But I also wanted to ask you, is there anything which, in your view, about the bill or about the context, which we have not covered many things, obviously, but which, in your view, requires specific mentioning? So I just open the floor for all three of you, in case you have something to articulate which we didn't cover, but which would fit perfectly into the tonality of the discussion. Vikas?
Thank you, Oles. My views are very much clear. Yes, we needed such a structure. That's when that was needed. So thank you so much for coming up with this kind of a structure, suggesting the structure. I hope this structure will see the light of day very soon. So far as the substance of this structure is concerned, by and large, it is good. I will give it 7 out of 10. There are certain nitty-gritties, there are certain problems, there are certain sharp corners which need to be edged out, like participative regulation, like the absence of structural remedy. But I'm pretty much sure, India did not have to reinvent the wheel. And slowly and slowly, with the participation and discussion, they will be able to fine-tune this structure. So what we have now, we can only improve it gradually.
Many thanks indeed. Vikas, Manjushree?
So it's always a slightly difficult position to take an independent position on this, because I've advised the government of India for a year now on the digital competition bill and the CDCL report. I've been a part of these deliberations for a year. So it's, to sort of summarize it, I think if I were to put my favorite phrase that I'm trying to write, about the digital competition bill, is that the road to this bill is paved with good intentions. But I am not sure if that's going to translate into good outcomes before we do certain things to make that a success. So yes, do we principally need a digital competition framework of this nature, an ex-ante framework for India, or a developing economy that has a digital ecosystem that it can take to the world? Yes, because competition is only going to help innovation flourish. But what's the right way to do it, and how do we sequence our steps of reforms, especially when we are talking about a country with lower state capacity than the counterparts that have effectively come out with a statute of this nature, which is the DMA. I think our approach there has to look slightly different. So while I'm with the bill and the report in terms of what its aspiration value is, I would like to see a little bit of homework in terms of capacity building, in terms of market studies to identify who should we really be going after, because the CCI has just one study on e-commerce that came out in 2019, and we've not seen any market studies that sort of go into the depths of at least the core digital services that we're targeting through the draft digital competition bill. I think understanding what are services we should target, who are the ones that we should go for, I think requires a little more evidence-based approach, which I would love to see before this bill becomes the reality. But it is a great step to start this conversation, and that we've acknowledged that digital markets do require a new way of thinking about antitrust, and I'm quite glad that's catching on in India. But we do have a lot more homework to do before we get back to the drawing board. I think that's where I leave.
Many thanks, Manjushree. And Gokul?
Well, yeah, I'm just going to say that first, there needs to be more emphasis on capacity building. I would agree with Manjushree. The second thing I would want to say is that India's DPI is going to catalyze innovation, will have significantly, will likely have very positive impacts for the digital ecosystem. And the other one, in just one sentence, I would say that what is very crucial, not just for the digital economy, but more broadly also, are economic development policies. And so if we get a lot of these things right, that should kind of that should kind of help, because with time it seems that the regulator will learn. The regulator is going to be able to generate more expertise, learn more, do a lot of other things. But ultimately, economic development policies also matter quite a lot.
Indeed. And now let us finish.
Just one more point.
Oh, yeah, go on, please.
Yeah, just one more point. It's more specific to ex-ante regulation, which is that the other regimes that have been devised, apart from the EU, for instance, the UK, they and maybe in other jurisdictions as well, they could also be kind of looked at.
Absolutely. And I think that that's something that's fantastic, because the report actually looks at a bunch of jurisdictions, about 13 of them, goes in depth to about 8 of them. But we've seemingly favored the EU model over the other models for reasons that I'm not sure we understand through the report. But my understanding is that because our jurisprudence is so heavily influenced by EU competition law, that's a favorable model for us to look towards. But I think when EU and India fundamentally differ in how their ecosystems are designed, I think there is a need to examine what other jurisdictions are doing a lot more keenly than how we've approached it at the moment.
Vikas, do you want to reflect on? Vikas, Gokul, do you want to reflect on this point?
I have just one thing to add, that the parliamentary, and I've alluded to this, I've spoken about this before. The parliamentary committee set a strict mandate that the TMA is what should the legislation should be modeled on. Perhaps that's what influenced the committee's deliberations. But I would say, as a supporter of ex-ante regulation, as somebody who sees, I think the TMA is a great piece of legislation, but it's always helpful to look and learn from across the world. That's all.
Thank you.
Oh, it's my last point. See, I'm a lawyer. I'm a legal academic rather. I would say that, no legislation is set in stone. It's an organic entity in the sense that it interacts with its surrounding, its ecosystem, its environment, and then changes its form and color. This is the same with any piece of legislation. Look, the way we started with the Competition Act 2002, it has changed quite a lot. The Intellectual Property Act, it has changed quite a lot. And this legislation, this ex-ante framework, is all the more prone to changes because we do not understand the ecosystem as such. The environment is dynamically changing. So let's have our faith in the system, faith in this piece of legislation, the new baby on the block, give the blessings, and just expect that after interacting with the environment, it would be more optimal than what it is now.
Many thanks. Manjushree, I would offer you the floor, but it will continue ad infinitum. So, and that's a privilege to have a kind of discussion where we have diversity of views, well substantiated, etc. But let us close with traditionally your recommendations to students. And Vikas, again, floor is yours.
Yeah, thank you, Alice. I'm an academic. I love talking to students. So my recommendation to the students is that now we do not live in silos at all, academic silos, in the sense that if I'm doing competition law, I have to talk to political science people, I have to talk to technology people, and I have to talk to definitely, we were talking to the economists for a long time, but we realized that the war is too important to be left to the generals. So we realized that in the case of digital economy, we need to talk to social scientists as well. So my recommendation to the students, talk to everybody. You never know, like it's like disruptive innovation. The great ideas that disrupt the world come from the blind corner. Maybe a sociologist wakes up one day and says that you have been doing it wrong all along, do it better. And as sponge, we are competition law and law in general. We absorb the idea and we make ourselves better and better. Thank you, Alice.
Thank you very much, Vikas. Manjushree.
Small, quick summary for law students is do participate in these conversations, because there is no way to learn if one does not make mistakes. And I'm sure there is so much for me to learn, because I have some total of 5 years of experience in this field, and I've only worked on competition so far. But there is so much to learn every day. So the public comments for the draft digital competition bill is open until the 15th of May. So do give the entire report a read, and something might leap out to you in terms of what's happening in another jurisdiction that may be more fit to what we can do in India. So I think it's just best to have an open mind and participate in these conversations, because it is the best that we can do as as a populace that shapes democracy in India.
Many thanks indeed, Manjushree. Gokul?
Well, my advice, I don't know what advice but I will say that, always stay a student, read widely, try to think broadly, and yeah, that's it.
Absolutely. Vikas Kathuria, Manjushree, Gokul Plaha, many thanks indeed for this very engaged and informative conversation. I learned a lot, and it was a pleasure to see you today.
Thank you,
Thank
Louis.
you.
Thank you so much.
Thank you, Manjushree. Thank you, everybody.